So Hanley, are you able to give me, do I need permission from you to share my PowerPoint?
Chief, we're going to go ahead and welcome the public now
Okay.
to our meeting. This is our City of Spokane City Council study session, and I'm Candace Mumm, Council President Pro Tem, with Council President Brand Beggs, who is part of the presentation today, and I will turn it over to him.
Yep. Good morning, everyone, and thank you.
Council President.
Thank you, Council President Pro Tem Mumm, for taking over responsibility and leadership of these meetings for the next few weeks. I did say that if I was feeling well, I would attend, and I am feeling very well today, and partly because I don't have as much of the burden that you're taking on for me. So thanks for doing that. And today we're mostly going to hear from the police department and perhaps city legal about changes that the legislature made to police practices last year. The police department and the legal department have been working really hard to analyze. There's a lot of changes. The changes were made by a broad stakeholder group of mayors and some police chiefs and police unions, and then there were other police chiefs and police unions and mayors who weren't as happy. There was a lot of back and forth, but eventually the legislature worked through a compromise, and that is now the law of the land. And so I know our officers are going to be following that as best they can, but there will be a learning curve and a transition as we adapt, just like we have over the years, to Supreme Court rulings, to a better understanding of how to enforce domestic violence laws. It's always been a process, and it hasn't always been pleasant to go through it and to do it. So what I was hoping to hear today is how our many officers who work so hard every day are going to be trained on this, and how they're going to adjust as best they can to follow the law and the spirit and the principles of these reforms, knowing that there's still a few interpretations out there and there might be a few tweaks down the road. So with that, it sounds like I am turning it over to Chief Meidel, and take it away. But we do have Mary Muramatsu, who's the legal department expert on policing, and I see City Attorney Mike Ormsby as well.
All right, very good. Thank you, Council President. So we have two different PowerPoints that we could review. I'm going to review the one put together by WASPIC, which is the Washington Association of Sheriffs and Police Chiefs. The other PowerPoint I have is a PowerPoint that our training cadre put together for all the patrol roll calls as well. So last week we hit every single roll call. It took about 2 hours to get through the training PowerPoint. This one I'll go through fairly quickly. My understanding is I have about 45 minutes. So I will try to go through these fairly quickly, and please interrupt if you have any questions or points of clarification. And then if I don't have specific answers for you, some of these bills are fairly long. I'll take a note and we'll get those answers for you. So I'm going to start sharing with the group my PowerPoint. Can everyone see that? Okay, perfect. So this again, this is the legislative update PowerPoint put together by the Washington Association of Sheriffs and Police Chiefs. The reason I'm using theirs is it encapsulates pretty much the bulk of the bills that impact law enforcement to a greater or lesser extent. You'll see that James McMahon, the policy director for WASPIC, was involved, as was our very own Mary Muramatsu. She's been a tremendous resource for WASPIC as well as some of the other legislators in our region. So again, they just throw out the disclaimer, talk with our legal, don't listen to WASPIC for legal input. House Bill 1054, and again, forgive me while I talk fast, there is a lot of material. Please interrupt if you want me to go into anything in more detail. House Bill 1054, known as the Police Tactics Bill. This bill, which is now a law, prohibits chokeholds or neck restraints in any circumstances, prohibits no-knock warrants. Now in Spokane, we did, talk with my staff, we've done one no-knock warrant in about the last 20 years. That's typically based on information that the individual says they're either not going to go back to prison or you're concerned evidence is going to be destroyed before the officers can make entry. Having said that, only one in about the last 2 decades that we were able to find that we've used. The use of K-9 teams, the Criminal Justice Training Commission has been tasked with coming up with a model policy for the state. They have a committee that they have put together, and we expect that we should have that model policy hopefully towards the end of the year. And then, Mary, you may have more information or updated information, so I will not be offended if you chime in at any time as well. Tear gas. So tear gas can now be used in 3 specific circumstances. If there is a potential for harm posed by a riot with the approval of the highest elected official in that municipality or county, can use tear gas for a barricaded subject after following some guidelines of attempting to exhaust all efforts to get the individual to exit peacefully, giving them an opportunity to exit. And I'm thinking of usually where we're using these are going to be a lot of our barricaded subjects. They're either barricaded the house or the attics, things like that. You have to give them an opportunity to surrender peacefully. You also have to exhaust all other efforts at attempting to get them out prior to deploying tear gas, and that tear gas can only be used with a supervisor's approval. And then the third scenario would be...
Excuse me, Chief, I have a question.
Yes.
Before you go on, so you said that before deploying tear gas, you have to have the highest, what did you say? Not supervising, the highest what?
For riots, if you're going to use them in what is a riot that is occurring, you have to obtain permission from the highest elected official in that jurisdiction before you can deploy tear gas at a riot.
And so what would that be for us?
For the city of Spokane, it's the mayor.
Okay.
Currently for the county, it is the chair of the county commissioners.
Okay, thank you.
You're welcome. And then the third scenario where tear gas can be used would be on a hostage situation as well. The 5th bullet there spells out what officers must do. It's obviously exhaust all alternatives prior to deploying tear gas, get that authorization from a supervisor on scene, and then announce the intent to deploy tear gas. And then, of course, give them time to respond to those announcements to peacefully surrender as well. And then the last bullet there just outlines that basically in the city of Spokane, before deploying any tear gas at a riot, we would have to receive pre-approval from the mayor. Continuation, this prohibits the acquisition of military equipment, and any military equipment must be returned or destroyed by the end of next year. It's not all military equipment. So, things like helmets and vests, things like that, the legislators were still okay with law enforcement agencies retaining those. This was more of the, munitions and weapons platforms, certain weapons platforms, things of that nature. Again, this one's not going to have a huge impact on us. Anything that we did obtain from the military surplus program were things that were already, that really weren't covered by the changes. So this won't impact SPD at all. Again, if you go to the third bullet, this requires all police officers to be reasonably identifiable by either a name badge, personnel number, some unique number that is specific to that officer. One of the things we did have to change our practices here, for example, for our TAC team and our SWAT team. So the bigger, thicker vests that they tend to wear didn't have anywhere where those were readily attachable. We have fixed that, so there will be a specific, unique identifier on those that equipment as well. Vehicle pursuits, those are basically statewide prohibited, except in narrow circumstances for specific violent crimes. The majority of those are going to be what we call our BARC crimes. The first 3 burglaries, arsons, first 3 robberies, kidnappings, homicides. You have to have probable cause that the person you're looking for is in that vehicle before you can initiate the pursuit. This will make a little bit of a change in Spokane, not significant though. We updated our pursuit policy about a year and a half ago. The other caveat, let me make another comment on this, the carve out for vehicle pursuits is also, so an officer needs probable cause to believe the suspect in those violent felonies is in the vehicle before initiating the pursuit, or reasonable suspicion to believe that the individual that is driving is under the influence of alcohol or drugs as well. So probable cause for violent crimes, reasonable suspicion for DUI, And before the officer can initiate that pursuit, they need to obtain supervisory approval. And one of the things that we made very clear to officers too is that doesn't mean you do a quick follow while you're waiting for permission to pursue. That means until you get permission to pursue, you're required to basically not pursue the vehicle. And a pursuit can be without lights and sirens as well. So we told our officers, don't do that. You need to get that supervisory approval. You also have to believe that the person in that vehicle is going to be an imminent threat to the safety of the community or the officers as well. So a couple different prongs there related to pursuits. The last bullet, shooting at a moving vehicle, that's already been our policy unless the vehicle itself is being used as a deadly weapon and the officer needs to use deadly force to stop the driver of the vehicle from using that vehicle as a deadly weapon. And it's all under the prong of imminence. Not that you're worried in 10 minutes or 15 minutes that that driver may use that vehicle as a deadly weapon. Is that vehicle being used as a deadly weapon right now as well? This basically allows for some shifting of funds from the criminal justice accounts.
Hey, Chief,
Yes.
Before you leave the pursuit, I just had a clarification just so I understand what you all mean pursuit. Let's just say somebody, you're driving in the normal course of speed, you're following a driver that starts, going over the lane lines, and so you have reasonable suspicion that they're impaired. When we talk about pursuit, that would be like going above the speed limit or something. So can you follow in the normal course of traffic while you're on the radio asking for your supervisor?
Yes. For the felonies, though, typically if it's going to be a pursuit, they're going to be exceeding the speed limit, and they're going to be going through stop signs, stop lights, uncontrolled intersections. So it's a slippery slope. It's easy for officers to get pulled into those.
No, I understand that, but I'm just again, to me it's a pursuit when you start doing something other than going to speed and, like you say, going through lights and signs and things like that. Okay, great, thanks.
Absolutely. So this allows the repurposing of fundings from the criminal justice, the 1/10 of 1%, to help with criminal justice system, homelessness, improving behavioral health. Go through that real quick. The only reason I bring that up is WASPA covered that. So this has to do with impeachment disclosures in Brady lists. Basically, this does require the prosecutors to develop a written protocol, basically by summer of 2022, July 1st of 2022, covering what their expectations are for agencies to disclose conduct to the prosecutor's office, how that Brady information will be shared and maintained, and then under what circumstances may that officer be removed from the Brady list as well. And then that list the protocols have to be reviewed every 2 years. And then the Criminal Justice Training Commission will provide training. And then we as an agency and all agencies across the state are required to report any Brady issues within 10 days as well. And then also as a mandatory step in the background investigation, if we're going to hire a lateral officer from another agency, we must contact the prosecutor's office to determine if the lateral is on a Brady list for the prosecutor's office in that jurisdiction as well. So this has to do really when you're looking at the officer-involved shootings. This allows the state auditor with the Criminal Justice Training Commission to conduct an audit of deadly force investigations. So when we say audit, this isn't to come in and find out did the investigation come to the proper conclusion. This is really to look at were all policies, laws, procedures, those things that are spelled out in the RCW. Did those agencies follow all the necessary protocols that are required by law? So this will be an audit in essence to make sure agencies are following the law. It's not designed to look at outcome, but rather to look at processes and ensure that processes were followed. This one has to do with the SAK3s. Those are the sexual assault kits. So we must notify the Attorney General's office on a quarterly basis of sexual assault kits, the investigational status of those. I think most of the council probably remembers you all approved a grant through WASPIC for us to assign 2 of our staff to do follow-up on all of our sexual assault kits. we anticipate we should be caught up with the backlog of those within the next couple months as well. And then for those who have been the victim of a sexual assault, it does require law enforcement provide a timely notification as to the status of the investigation as well. We have a phenomenal partnership with Lutheran Community Services and YWCA and the advocates that they have. I definitely want to give them a shout out for being amazing partners and helping us with a lot of these processes as well. Juvenile access to attorneys. Now, this one actually goes into effect January 1st of next year. In essence, this requires that before an officer interviews a suspect that is below the age of 18, the officer must, required, without exception, contact an attorney for that juvenile before that officer interviews that suspect. It also does not allow the juvenile to waive their rights to contact an attorney. That is mandatory. They can't say, I don't need to talk to an attorney. I don't want to talk to an attorney. So we will be required to contact an attorney. We're working right now with the city on on-call attorneys. So for an example, for DUIs, the city has on-call public defenders for those who have been placed under arrest for DUI. It's supposed to be 24/7. This will follow a similar model as well. If they have their own attorney, we're happy to make that connection. If not, we're working on a process to have a public defender available for them 24/7 as well. And then again, if they are not given access to that attorney, the statements they make will not be admissible in court. Again, this is just juvenile rehabilitation. Basically, it allows those who have been juveniles who've been charged with certain crimes to transition to community transitional housing a little bit sooner than what the law was prior. This one doesn't directly impact law enforcement, other than typically if we stop someone for an infraction, then we ask for the driver's license. But I just thought a lot of the community might know we're now going to a system where your driver's license can be good for 8 years. And there is an ability to renew online as well. I think that's a great thing. I think it's going to save a lot of time as well. I just put that in there more of an informational, so you won't have to go down and stand in some of those long lines. The reason I put this one up, K through 12 safety and security, and we will get into the little more details in some of the one of the future slides. So District 81 Spokane Public Schools had a limited commission officer program through the Spokane Police Department. That limited commission officer program allowed them to basically enforce and process for certain crimes, not carte blanche, but just certain crimes that occurred on the school grounds or that evolved around students that attended the schools or staff. I put this on here because the limited commission officer programs, the requirements for the LCOs fall under the same requirements for reserves, which means they have to work for the police agency, they have to be polygraphed, they have to go through the backgrounds. So, you know, state law requires the polygraph exam, but on the other hand, unless you are working for directly a law enforcement agency, we can't give the polygraph. So there's been a significant change in our limited commission program as well. So this is basically, again, not a huge issue for Spokane PD since all of our officers have body cameras, but this requires that any adult that is interrogated regarding a felony or any juvenile for any offense must be both audio and video recorded in the jails, cells, by law enforcement officers, and if it's not in those facilities, law enforcement offices, and if it's not in those facilities, at a minimum, it must be audio recorded. We have body cameras. This isn't going to be a huge issue for us since last 5-6 years, we've already had body cameras as well. Child abuse allegations. So this really, this gives officers, I would argue, and Mary, correct me if I'm wrong, a little bit more leeway in taking a child into protective custody if that officer believes that child is in imminent physical harm due to child abuse or neglect, which could be sexual abuse, exploitation, pattern of severe neglect, or if the child would be seriously injured if the officer just left as well. So this does give us a little bit more latitude to go in and say, we believe this child is in grave danger. Under this RCW, we're now allowed to take that child into protective custody as well. So the Office of Independent Investigations will report directly to the governor. This is basically going to allow the state, this OII, to conduct independent investigations of any officer-involved shooting anywhere in the state. It does not mandate that they do those investigations, but it gives them the ability to come into any jurisdiction and on any officer-involved shooting that they would like to investigate, they get to come in and have the priority in those investigations. A lot of details to work out still in terms of staffing, having different response units throughout the state. If you're, as you all know, if you're involved in an officer-involved shooting, you have to lock down the scene until the investigation is over. So, for example, in Spokane, we can't necessarily have a team over on the west side unless they can get here within a couple hours. So right now they're working out all the logistics of how does this work, what's this going to look like, and who is going to be on the OII as well. Use of the force. This basically allows an officer, authorizes an officer by law to use force, reasonable force. Every time I say force, I'm just assume it's prefaced with reasonable force to protect against criminal conduct when the officer is making an arrest. It allows the use of force to actually make an arrest, to prevent the escape of an individual who is in custody, or to protect against an imminent threat of bodily injury to any person. So the imminent, again, there's no specific definition in this bill, but our explanation of the officers has to be immediate. So there has to be an immediate threat of bodily injury to the officer, to another individual, or to the person themselves. It requires that officers only use deadly force when necessary to protect against imminent threat of serious physical injury or death. Officers must exhaust all available and appropriate de-escalation tactics prior to using any force, and then use the least amount of force that's necessary to overcome the resistance. And then as soon as the use of force has successfully got that person into custody, that use of force must cease. So by July of next year, the Attorney General will develop and publish a model policy on use of force and de-escalation for the entire state. It requires all jurisdictions to submit their use of force policies to the Attorney General's office. And then if the jurisdictions do not follow the Attorney General's policy on use of force or de-escalation tactics, then obviously you need to notify the Attorney General's office as well as why you would not be following that. So we're definitely looking forward to seeing that model use of force policy. I think that's going to help fill in a lot of gaps right now. Again, I threw this on there, the school mapping. Some of you may have heard of this. The state at one point paid to have every single school in the state mapped for various tactical responses, for fire responses. I just put that on there if you've heard about that program. Not widely used by most jurisdictions, and not because it wasn't an effective program. I just think most jurisdictions didn't find the need to necessarily use that. So if you've heard of the school mapping program, the funding is gone for that as well. This one has to do with open carry at permitted demonstrations. And in essence, what this means is that if there is a permitted demonstration, individuals are not allowed to open carry any firearm within 250 feet of that demonstration. It does not prohibit concealed carry. It just means you cannot carry your weapon in the open, whether it's on your hip or a rifle that you have slung over your back or your chest within 250 feet. And then, of course, for the Capitol grounds as well, at any time, there cannot be an open carry. Decertification. So the Criminal Justice Training Commission has prongs where they can conduct their own investigations of allegations of misconduct against any jurisdiction in the state. And in the course of that investigation, it does allow them to come up with their own findings, and those sanctions, the sanctions that they can impose can be additional training for that officer or deputy, temporary suspension of the certification to exercise law enforcement duties, or removal of certification, meaning they cannot be a commissioned officer or deputy in the state of Washington. It also allows them to make public recommendations regarding decisions related to the investigation, policies, training, disciplinary decisions, potential systemic violations, unconstitutional policing. So it's really a level of oversight regarding investigations on top of the oversight we have in our community as well. And then, of course, it expands requirements relating to pre-hire background checks. Shared some of those with you as far as the Brady list as well. And then it does require that law enforcement agencies notify the Training Justice Commission within 15 days of any occurrence of a death or serious injury related to use of force, or any time an officer has been charged with a crime as well. And there are some monetary penalties. So if the officer or the employing agency does not report timely and accurately the requirements of this law, there is a $10,000 civil penalty for the officer and or the employee agency as well. This records retention for all corrections in law enforcement in the state. All of their employment records must be maintained for a minimum of 10 years. It requires that the Training Commission maintain a searchable, readable, exportable database on the investigations and the findings, the certifications, all the things that are basically encapsulated in this bill. They have to develop a database that will allow community members to go and search that database as well. And the fourth bullet, they're the only ones who can provide basic law enforcement training. That's currently the way it is right now. Burien and Spokane are the only two police academies authorized to commission officers and certify officers as well. One of the things as well is it's not common. I wouldn't say it happens every time, but an officer that may have engaged in misconduct may just decide to retire or resign before that investigation is complete. Typically, agencies have suspended that investigation. If they've retired or resigned, you don't have that ability to compel them to come in for an interview anymore. That's why you'll see that most jurisdictions suspended those investigations. This law now requires that, regardless of whether they've retired or resigned, that investigation must still be complete. And then the last bullet is anyone who is interested in applying to be a police officer must waive confidentiality agreements related to their employment. Grievance arbitration panels, this isn't going to really impact when you're looking at things like wages, impact to working environment, things like that. But basically it requires the Public Employment Relations Commission, PERC, to establish a list of at least 9 and not more than 18 arbitrators, so that if there's a grievance filed by a union against a department and in the city related to discipline, for example, discharge, termination, this requires that the final arbiter of that grievance will be a member of PERC. So each jurisdiction used to have their own list of arbitrators that they would pick from. We typically had 5 here. This basically is now saying we're going to actually remove those from each jurisdiction, and is now going to be PERC that is going to be the final arbiter of those grievances as well. A duty to intervene, we did have this in our policy. We did strengthen our language on this. But basically what this says is if an officer sees another officer, whether it's the officer that works for that agency or another officer using what is excessive force, they're required to report that to their supervisor. And there are penalties, including potential removal of certification if they fail to report what they're seeing as excessive force as well. And of course, departments cannot discipline or retaliate against officers who do report what they believe to be excessive force. The duty to render first aid, this is something we've had for several years now. This won't be a change for us at all. And then any and all disciplinary decisions must be forwarded as it relates to the duty to intervene or reporting, must be reported to the Training Commission as well. And then, of course, CJTC will have a model policy by the end of this year. And then all officers must be trained on this by December 31st of 2023. That's the latest that departments can be trained on this. And then they will incorporate this training into the basic law enforcement academy starting January of next year. This is basically just, again, about some more transitional housing into the community graduated reentry program. This is one where if someone calls and falsely reports an incident to get a police response, this is a law that will basically create a $250 infraction against that person. It allows that person that has been a victim of calling in to sue that person for reasonable costs, including attorney fees. So if you remember, I think one of the genesis of this was a incident in a park where a female confronted an African American and was recorded making false allegations of what she was going to relate to the police department. So this establishes a statewide law. We already have it in Washington, what's called false reporting. We technically could already have enforced this. This is just a different prong that allows for enforcement as well. And we on occasion have enforced false reporting for folks who have falsely called into law enforcement to compel a police response. This has to do with sexually violent predators. Again, this is about transitional housing. My understanding is there's an effort to try to get them more counseling and more resources for those who are sexually violent predators, and trying to get them more out of and from underneath the Department of Social and Health Services. So driving while license suspended, Spokane, I think, has been ahead of the pack on this with their suspended driving court. I think it was definitely innovative for the state, if not the nation. This basically says that the state will no longer suspend a person's driver's license because they have not paid their ticket or their citations. Where they can be suspended, though, is if they get 3 or more moving violations in 1 year or 4 or more in 2 years. And I'll explain the moving violation very briefly. If someone has expired tabs and an officer stops them because their tabs have expired, that's not a moving violation. If someone has a burnt-out taillight or a burnt-out headlight, that's not a moving violation. A moving violation is going to be speeding, fail to signal, improper turn, things of that nature. Law enforcement data collection. This is going to establish a centralized data collection for all jurisdictions across the state to forward their use of force data. Right now, they've put together a committee to work on what data do we want to collect. And I believe, and unless Mary has updated information, they're still trying to determine what institution will be the repository for collecting all of that data as well. So that's, from my perspective, that's not a bad thing. I think most chiefs or sheriffs would like to know, how are we comparing to other areas? Well, understanding there are different variables based on where you live. I think variables in Spokane are going to be different than those that are on Whidbey Island and things of that nature, but it's certainly something I think that we would all be interested in looking at. Felony bar. So basically what and Mary, definitely weigh in on this one. This is more of a legal process in the courtroom. And Mary, do you want to explain this one real quick? I know just enough to be dangerous.
Essentially, whenever a plaintiff aggrieved by a police use of excessive force brings suit against the city and the police department, it's a defense to that action that the individual has committed a felony. And so that's typically a civil standard, but now under this new law, it is something that has to be proved beyond a reasonable doubt during that civil trial. So we have a criminal standard of proving that the person committed a felony, proof beyond a reasonable doubt, as a way of a police officer defending him or herself from that action. If in fact that can be proved beyond a reasonable doubt, then it's a complete bar to the claim for unconstitutional excessive force and damages, essentially. That's what that is. So what the legislature did was they made it more difficult to establish that this person committed a felony as a way of defending a police officer. I don't know if anybody has questions on that, but that's kind of a simple explanation of that.
Thank you, Mary. State versus Blake. This has to do with the I believe, Supreme Court ruling that it had to do with the actual drug case in Spokane, where the defendant had indicated the drugs in her possession. She did not know they were in her possession. So the Supreme Court struck down the law. What this new law now basically says was that when an officer encounters someone with controlled substances, on the first 2 separate contacts, the officer or deputy must refer them to treatment or counseling for that potential drug addiction. If after the second separate contact, The officer then contacts that individual again. At that time, then the officer or the deputy can issue a citation to that individual, and that will go through the court systems as well. It also encourages the prosecutors to divert those cases that do come to their attention to treatment as well. So it took possession of controlled substance from a felony to a misdemeanor on the third contact as well. And I believe the council is going to get this for voting on the local ordinance next month as well. This is just really a continuation of this. The city is going to appropriate $88 million for substance abuse assessment, treatment, and recovery services as well. Also, it's important to note possession of drug paraphernalia is no longer a misdemeanor as well. So it's important to note that as well.
Excuse me, I have a question. Can you go back, please? Thanks. So we have a couple of laws around drug paraphernalia and use and possession around parks and places where, and schools, places where children are. And I guess this is a Mary Miramatsu question. How is this going to affect those laws that we put in place? And some of them are fairly recent. How are those going to need to be changed? And if so, how?
So what the legislature did, in addition to modifying the penalty for simple drug possession, is they decriminalized certain aspects of the use of drug paraphernalia. So prior to July 25th, actually it was prior to, I think it was May 13th or 18th, it was an earlier effective date, but the use of drug paraphernalia to inject, ingest, or otherwise introduce a controlled substance into the body was illegal, as was to cultivate, to grow, and to use paraphernalia in other ways. What the legislature did was they continued the illegality of growing it or cultivating it, of using paraphernalia for those purposes, growing, cultivating, and other such matters. But they decriminalized using drug paraphernalia to inject or ingest a substance into the body, okay? So that aspect of drug paraphernalia is no longer illegal. So it is necessary for the city to amend its use of drug paraphernalia ordinance to match what the state law says. Otherwise, we would have an ordinance that's inconsistent in terms of what's illegal and penalties, and the state, at least in terms of penalties, preempts the field in terms of this type of offense. So in a proposal that we are advancing, which adopts pretty much the State v. Blake changes to Senate Bill 5476, we're recommending language that not only adopts the state law, 6950-4013, 4011, and a couple of others. It's basically counterfeit drugs, legend drugs, simple possession, possession of marijuana at certain amounts, and the use of drug possession paraphernalia. So all of those are coming to City Council within the next few weeks to consider. Lori, does that answer your question?
It answers part of my question, and I guess I'm concerned because we're trying to help our parks stay safe. And to me, I'm looking at this going, this is not going to help. So I'm wondering if we can come up with something, be a little creative so that we can continue to have our parks and areas around our parks safe for children and for people to recreate safely.
So, Mary, I think the question is, just like we can ban smoking in parks, although it might be a infraction instead of a misdemeanor, can we say parks and schools are so special that there are different paraphernalia rules? But maybe it really is just, it has to be an infraction, not a crime. So.
Probably an infraction. I think the other tool that the Parks Department has is, and the city in general, is the use of exclusionary notices. So if a person is excluded from a park because it violates the park rules, to be using drug paraphernalia and drugs in a park, then the tool is that of exclusion. And of course, if a person comes back having been excluded, they could be subject to ticketing for criminal trespass. I mean, there are other ways to explore, and like you said, Council President, that the use of an infraction, I think, is also another way to go about it. So that's something we can take a look at.
I see Councilmember Cathcart. I know Councilmember Kinnear and others may have also questions. Councilmember Cathcart.
Yeah, thank you. Is it true, I had one officer tell me that you can no longer use drugs as the basis for addressing any sort of nuisance home. Is that true, that it now has to be some other crime or level of crime to address nuisance homes?
I am not aware of that. And Chief, maybe you have different information. I don't know why that would no longer be the basis for closing a house. In fact, that's defined as nuisance activity. But I haven't spoken to any of the officers about this.
Yeah, it's an interesting question. So if in essence, possession of controlled substances, what used to be a felony, if the first two contacts now are referral to treatment, that's an interesting legal question. So do officers first have to contact the residents or those in the residence, say, here's your referral. If we come back a third time, then we're going to give you a misdemeanor ticket. And at that point, does that then give enough to do what we've typically done? That's a great question. So,
and honestly, they may be two separate issues. You know, the statute is really clear that if you serve a couple of search warrants at a house regarding drug activity, that alone is the basis to file a complaint to Superior Court and for them to shut down the house. So, you know, I think we have a different set of standards going on. You know, you can not cite somebody criminally for the possession of drugs if, in fact, they have to be referred twice. But if they're running a nuisance house, that's a whole different set of laws and a whole different set of standards. And I'm not sure I see any barrier to moving forward with a complaint for abatement. That's something that I think we need to further explore. I don't see how that's been abrogated at all. I think we still have those powerful tools that the legislature gave us.
Okay, I appreciate that. It could just be a misinterpretation. One other quick question. So last night in Puyallup, there was a person who was killed, and I'll just read from the Cairo article. It says, we did have a canine officer respond within a couple minutes, but unfortunately, because no probable cause was developed here for an individual, they decided not to track with a canine, just in case if they did use force, it wouldn't be outside of the policy of the new laws. That's according to the sergeant with the police force there. And my question is that kind of how things will be treated here in Spokane? And if there is the possibility that this person has run into a neighboring home or is still a danger to the community, is there any leeway at all to track and try to detain and stop a person who has committed, you know, a crime like this?
So yeah, right now, so officers can request anyone that they believe may be involved in a crime. They may request them for voluntary compliance. If that person refuses, then the law now says officers must have probable cause to use any level of force to detain that person from fleeing the scene. So going to an example of canine deployment as well. So, you know, we actually had some of our canine handlers in the trainings that I went to, and like they pointed out is typically for our canine handlers, they wait for probable cause anyways. If they're tracking from a house, and a lot of them tend to be domestic violence suspects that flee out the back door or something like that. So what they're required to do is, and we call it investigation. Investigation can be as quick as contacting the victim. What happened? He punched me. She's got a welt on her eyes. I now have probable cause. So going to the one in Puyallup, they may just, if it was, and you said it was a homicide?
Yeah, a person was killed in a parking lot.
So and these are the questions we get at roll calls all the time as well. If you have a homicide, do you know if the person fled on foot? And then the challenge is, depending on the scenario, like out in the valley just a couple of days ago, we had the shootings where someone lost their life. You have people fleeing in every direction. So you don't know what scent, and the dogs track what's called spores. When we walk, everyone puts off spores. That's what they're smelling. So is the dog tracking spores from someone who's getting out of there because it's dangerous, or are they actually tracking the suspect? There's a lot of variables, and for our canine handlers, they would need to know this person who we have probable cause for went this direction, and they would leave the dog on a lead so the dog wouldn't just run off and bite anyone and everyone who's around. So they may just have a different policy for response on that as well. I would want to get more of the details as to did you have a specific suspect that you could track, or did you not? You got a call if someone was seriously injured, you responded, and you didn't know who did it yet. In that scenario, if you didn't know who did it yet, I don't think you would do a track in that scenario, because you don't have probable cause for a specific person.
Council Member Wilkerson is next, and then I see Council President Beggs. We are going over allotted time, but I think this is important, and council members have questions. Councilmember Wilkerson.
Thank you. So, Chief, one of the things I keep hearing is officers see someone downtown and they're shooting up drugs. They cannot arrest them until there have been 2 contacts. But if they don't go up and speak to the person, how do you keep track if there's been 2 contacts or not before you can cite them?
Yeah, so we, and that's one of the things we made clear too, is that with the first 2 individual contacts being a referral, and then the third one being a citation, we tend to be, as you know, a call-driven agency, calls in progress. Those are always going to be the priority. What Shauna Ernst with our TARU has developed was a system through, I believe, LERMS, so that on every contact, an officer will fill out a form, give the individual a form, and then to make a notation in our database system that will work for the county. It won't work for all of the state yet, but within our county, they'll be able to access that name and find out on this date at this time you were given this documentation. But the officer is going to have to make contact with that individual, in face-to-face contact with them, to give them that paperwork as well. One of the, and I know we talked with Mary about this, is that if those first 2 contacts aren't a crime, you take whatever it is that they've ingested and test it, because you still need to make sure that it actually is a drug. Is this heroin? Is it cocaine? Is it meth? Is it OxyContin? So some of the variables are you seize that and then test it, so that you can say, if you do have a third contact, yes, these 2 contacts, we tested it and we did verify that it was heroin, example. So there's some nuances with the first 2 contacts not technically being enforceable through a crime as well. I'm not sure if that answers your question or not.
It does. And Council President, I just got one more comment. Thank you, Councilmember Ramon Pro Tem. So, Chief, I'm really concerned. After the press release a couple of weeks ago of all the regional police chiefs in the area, misinformation got out there, and the community is like scared, because it sounded like this new law was taking away all your power. The sky is falling. Now there's misinterpretation, and people are living in fear. What type of messaging will we be doing to get the correct information out there to the people and to our law officers to do this work? Otherwise, we have created a bigger mess than what we had before.
So, yeah, the intent of that press conference was to educate the public, because quite bluntly, the laws have changed. When officers were able to use reasonable suspicion to detain someone, that they had specific articulable information that they were involved in a crime but not yet probable cause, and they were allowed to use reasonable suspicion to detain that person, that's gone now. You now have to have probable cause to detain someone who's unwilling to be detained. In other words, those who are willing to stay, that's great, there's no change. But for those who are no longer willing to stay until you can develop that probable cause, you can't use force. They can leave, they can flee. We had an incident yesterday on an OP violation where a citizen called in and said he saw a woman trying to grab a female. She was screaming for help. The officers responded. The male, in this case, who is the suspect, refused to stay. The female was not overly cooperative, but by the time the officers were able to get her information and his information, They developed probable cause. In addition, they learned at that point that he had an order of protection prohibiting him from contacting her. But those aren't necessarily things that you're going to get from one caller related to this incident, because when the officers showed up, they were both calm, they were both just standing there. So there's nothing to support the call that had come in, which is why they had to do the investigation. Well, that takes several minutes. And by that time, the person had fled in the neighborhood, was hiding behind a house. By the time they developed probable cause, he started jumping fences and running. So it will change what we are able to do. One of the reasons the courts have said that officers can use reasonable force to detain someone under reasonable suspicion if they believe they were involved in a crime is because they realize that by the time you're able to get to that threshold of probable cause, that person may be long gone. And if it's a stranger, like it's an aggravated assault, a stabbing, or something like that, who the victim doesn't know, you want to detain them at that time because that's your best opportunity to make sure they don't flee, to identify who they are. So there's different nuances as well, though. And one of the things I explained at roll call is that going back to the PowerPoint where the woman had said she's going to call the police and make these false allegations. So if the officers just responded based on everything she said and took what she said as fact, the African-American would have been arrested. Well, I think that's what the courts are worried about, is we don't want just reasonable suspicion. We want you to get to that threshold of probable cause. But in probable cause there's a definition for it, more than a mere suspicion that this person was involved in a crime. But when you only have one complainant and what the officers are seeing is different than what the complainant has said, they have to do an investigation, and they have to be able to find out this person did engage in this criminal behavior, but they can't use force until they get to that level. So it is going to change law enforcement and what our responses are. And you're seeing this across the state. And one of the things we've committed to, though, is we're going to do everything we can to keep the community safe. But we also need to let the community know here's what we can do and here's what we can no longer do as well. And the nuances are, if I have 3 separate callers, all about one incident, and they're describing the suspect and whatever the incident is, now I would say I've now got what's probable cause. I'm not going to necessarily arrest this person just based on what these 3 individuals are saying. I still need to do an investigation. But now I can say I have even stronger articulable suspicion based on 3 independent witnesses that this individual did this. I'm now more comfortable if they try to flee using reasonable force to detain them. But if it's just one person calling in, for lack of a better way, it's hearsay until the officers can confirm that information.
Chief, great explanation. We do have a couple more questions lined up here, and we have another presentation, so I'm going to keep us moving. Council President and then Councilmember Stratton.
Yeah, I just wanted to say 2 things. One, I want to go back to Councilmember Cathcart's concern, and I just wanted to say that I think the issue there is they just didn't want to let the dog go loose and bite anyone. That's one of the number one liability issues for police departments, when they just let a dog go loose and say, go bite somebody and hold them. And our department doesn't do that. We're much better trained than that. And what we would do is track somebody, but not tell the dog to bite them. So if I understood the chief, I just want to emphasize this. You could still use a canine to track someone. You just wouldn't take the dog off the lead and tell them to go bite that person unless you had probable cause. So it doesn't stop us. And we've heard tale after tale of great tracking, finding people who were, gone from the scene before the police got there by our canines, but they didn't necessarily use them to bite them. So I don't think we have that problem here. I just wanted to emphasize a little bit join Councilmember Wilkerson in my concern about it seems like whether it was intended or not, there was a bit of fear-mongering going on in the blogosphere and media sphere out there, and I don't think that's what we want to do. These are the laws that have been passed by the legislature after consulting with mayors and police chiefs and police unions, and I thought it was a great explanation, Chief Meidel, so credit to you for that. And I know you're using WASPIC, but you're currently the chair of WASPIC, so you get to take double credit. And I just wanted to mention that, the reasonable suspicion stop was a judge-created thing. That's not based on the Constitution and the Fourth Amendment, which didn't have that exception. And I see this law as just going back to the legislature and pushing back a little bit and making sure you have a little more. Probable cause is not beyond a reasonable doubt. It's not more likely than not. It's pretty easy to establish, but I think as Chief mentioned, there have always been some borderline cases where there's not quite probable cause and not reasonable suspicion. And what the legislature did is said, you know, one of the worst things that we can do in our country is use force against someone who's done nothing wrong. So they changed it just slightly, I think, in my judgment, not a police officer, but I've looked at many of these cases and totally understand it's going to take a while for officers to get the new line, but it's not a drastic line, in my opinion. For whatever that's worth, probably not too much. Thanks.
Councilmember Stratton.
So I just wanted to mention, Chief, that the other night I visited my neighborhood Safeway. It's colorful at night. There's lots of issues and lots of things that happen there. Within 5 minutes of being in the store, I had the night manager approach me to tell me that he had gotten a call from SPD, didn't tell me who it was, but basically told them that the police department would no longer be responding to their calls for help. And when I tried to push it, it was, well, you know, parking lot issues and trespassers and that kind of thing. So in the course of about 15 minutes, I had 2 other employees that came up to me that are now scared to work nights because if anything happens, the police won't show up. So I spent a lot of time trying to, you know, calm the situation down. But the other thing I did is talked about the cop shops. This particular Safeway on Northwest Boulevard has 3 cop shops around it. And so my goal is to get those managers Patrick's number and, you know, sometimes even a police car or the cop's car that says cops on it in the parking lot will help. I mean, there's some simple things that we can do to help these businesses. And so I guess I'm echoing what Councilmember Wilkerson said, is that there's a lot of fear out there, and I'm going to do my best to try and plug people into the COPS program and having that presence in the neighborhoods. But I just wanted you to know that I literally have had people say to me that police officers had told them, if you call the police, we will not show up. And I just find that I think we should be out there saying, okay, these are the new state laws, but here's what we can do. Here's how we're going to work with the community and work with the COPS program. Rather than the fear that night was, it was really unfortunate.
Yeah, let me, real quick, and I know you're on a time crunch. One of the things I told the roll calls as well is we are not looking for reasons not to go on calls. We are still going to go on the vast majority of calls that we go to. There's going to be some that we won't, because we can just tell that this has nothing to do with law enforcement at all. But we're not looking at these thinking, how can I find a reason not to go on these calls? And then we also may be clearing some of these calls a lot sooner. But some of the things you'll hear is that some of these businesses want us to come and just clear people off their property and tell them you need to leave, but they're not interested in pursuing any charges. And one of the things we've said is that, so one of the prongs of responding to these calls is if there's no crimes, the legislature said officers should consider leaving the area if there's no crime. If there's no crime, we're law enforcement officers. Some of them have said, we don't want officers going on calls that do not involve a crime. So when they're asking us to come and basically say to somebody, you need to leave the property, but they're not interested in pursuing any formal trespassing charges, it's like that's something where, the legislators have said, if there's not a crime, law enforcement, don't go on those calls that don't involve a crime. But there's that balance, and there's going to be some growing pains with this. So we can still go on any and every call that is there, but some of them, once we determine there's no crime, especially if there's an indication that force may be used, the legislature said officers should leave the area, which we're interpreting as leave the area if there's no crime and if you think there's going to be a level of force. So that's an educational piece. One of the things that's going to help is also, if I can get the names of those who have done that, and we'll do follow-up as well with the department as well on these things, because there's going to be some growing pains. But officers can go on every call they've gone on, they're just going to be leaving some of them a lot quicker. And what I would want to ask the manager is, are you just asking us to go and tell them to leave, but you're not interested in pursuing anything? Well, you're the manager. You tell them to leave the property. If they refuse, then we respond. Then we arrest them for trespassing. Issue them a ticket for trespassing. But if all you're wanting us to do is come and be your mouthpiece to tell them they need to leave, that's something that we need the managers to start doing as well. And then when they refuse, that's absolutely, we'll respond to those as well.
Okay, we'll go ahead and wrap it up. I bet all of us have.
I would just like to see us, if we could, utilize the COPS program to help us get that information out, because if we all remember, that's community-oriented policing. What it used to be is that officer around the neighborhood that could pop in and say, hey, this is what we're going to do, this is how we're going to work through this. So that might be helpful.
Okay, love it.
Thank you. I think we could all have another half hour of questions, but out of respect of everyone's time, I want to thank you, Chief, for giving such an extensive presentation, and Mary Maramato as well. So we will probably be back discussing some of these things. Thank you, everyone. If you have follow-ups, please do contact them. We're now going to shift to ARP funds, and Council President, are you managing that one?
Yes, a little bit. I think we're going to start with a report on the initial thought exchange, and then I'm just going to give an update on progress. We thought we were going to be bringing actual funding proposals today, where the headline is we're not, but I'll explain why not as we're taking more time to do that. But the thought exchange was really exciting, so I'll turn that over to Lisa and Hannah Lee.
Good afternoon, Council. I'll definitely make this presentation short. I wanted to be able to share numbers with everyone of the thought exchange. We launched it last week, and we've had an impressive response within the week with thought exchange. So I'm going to share my screen to show the numbers and what we have going. Let's see here. Does everyone see my screen? Perfect. All right. So this was the initial question, the open-ended question that we asked the community. And I want to share just a couple of slides. So I won't go through the entire presentation. Let's see. All right. So far within this week, and this was pulled this morning, we've had 522 participants, and we've had over 1,000 thoughts and 15,000 ratings. So that's showing that the community is absolutely participating in this initial thought that we have going, or this initial question that we have going about ARP spending. This one right here is the question that we ask is if you live in Spokane or work in Spokane or own a business in Spokane. So we have a good majority that live directly in the city of Spokane. But the number that I'm going to show you next that I'm a little bit concerned about is by district. This is the statistics for each district and the people who are representing. And what I want to do is look at District 1, that's 7%, and wanting to know what we can do with District 1 to get a little bit more participation. But then we also have 28% unsure and they do not know what district they're in. So I think we're going to have to kind of tweak our thought exchange to perhaps add some information or geographic information on what district you possibly are in.
Lisa,
yeah.
If I can jump in, I think one of the problems is we also have a District 3 legislative district, which is very confusing for folks. So maybe if we had a map, that might be helpful.
All right, so that's something that we're looking to add to that is it shouldn't be that 28% is leading the way of not knowing which district they're in. And we want to figure out if there's any type of way of more engagement for District 1, and that could be that a lot of people are falling, that's in District 1, are falling into that unsure and don't know category. And so this is just the age participation. We're seeing actually the demographic kind of neck and neck here with the 30 to 44 and the 45 to 64. And those are people that, you know, statistically who are online, they're checking their social media, they're engaged with what's going on within their city politics. So that number is to be expected. So here we have a word cloud that really goes over what are the top thoughts that are happening. Childcare is our #1 thought. People really want to invest money into childcare, access to affordable childcare and resources. The next one you'll see is affordable housing. That's, of course, no surprise at all. Affordable housing and low-income housing. Those are the top three that we're finding. If we were to do a top five, it would be affordable housing, childcare, low-income housing, mental health, and climate change. As far as the top thoughts that we have so far. And as you can see here, this is kind of a bar score of the top thoughts that are out there in the top themes. And I think that a lot of them have the same theme where it says services for homelessness, low-income housing, affordable housing. That's, of course, to be expected. I think the ones that, for me at least, looking at this has been climate change, looking to work with environment. So I think that is something that is surprisingly high. And key thoughts are, of course, housing. Low and middle income folks are priced out of the market. Can't imagine what homeless people are facing in this market. That has about 957 people who agree with that thought. So we love the fact that people can agree with different thoughts that are out there. Again, this one is speaking towards housing. Again, affordable housing. And then this one, childcare. Childcare, again, has become, it's up there as far as also resources and workers. The workers are actually, they're exhausted, as you can imagine, and during the pandemic and actually the recovery. So I won't go through the whole entire presentation, but I wanted to show that we're getting a good response with that exchange.
Can you send out the presentation though to everyone, just so people, or something to everyone, just so they can peruse it, or a link to how they could see it, the data, however it is. I haven't used it yet, so I don't. Maybe it's easy to see, but whatever.
No, what we have here is what we download this information in this presentation from our dashboard, and I can definitely email that to council to look over.
Lisa, I'm wondering, do we put those statements in there, or are those statements generated by other people, or do they have the option to put their own ideas in?
Yes, we asked the initial question to provide your top three ideas. So these are thoughts that are generated from people, from the community.
And how long are we running this program? Through the entirety of ARP, or?
Right now, this is our first step in community engagement, so we don't have a date as far as ending this particular question. We can always change it as we move along in the process, but this is our initial, so I think right now for the next couple of weeks until we start to work with council members and administration on the actual process of ARP funding, I think we want to keep this open for a community to give their input and give their suggestions and ideas.
Other council members? And then Council President, do you want to give an update on what the process looks like? You said we were thinking of having some things come forward.
Yeah. Well, a couple of things. I just want to give an update. So again, we have a city council work group of Councilmember Stratton, Wilkerson, myself, and some staff members that are moving things along. And we meet weekly on Tuesdays. And we have hired Mackenzie Lloyd to be our project manager to help manage all the ideas that come in, and where are they in the process? Have they been presented to the work group? Have they been presented to council? Have they gone to the administration work group? Where's so that's Mackenzie is managing all that, and then relationships with people, some of our partners like Spokane Arts, and community centers who are saying, hey, we want to work with you, the school district on childcare, early learning. So, getting the information that we need. So Mackenzie, we'll send around the job description that Mackenzie has, but that's what Mackenzie is doing. We authorized, as you know, a little over a week ago, her position, and then a less than full-time community engagement position. And Lisa Gardner is, I think, pretty close to finalizing that person, or maybe not. She's looking at me no. So if not, then she'll be working on that. But we're trying to get that person in line so that they can be managing the public-facing community engagement. The process that we're working on is having, this database that any of you can see. You don't necessarily all have access to the database, but we can send you the spreadsheets of the projects that are out there. So we're trying to take those projects and ones that we think fit what council priorities council members have expressed previously, putting them into white paper form that would explain why they're compliant with ARP, why they leverage things on multiple levels. They obviously help people, but they build us back faster and will create more growth and revenue for the city in the future, and have triple bottom line kinds of things. We're developing new jobs, developing people, neighborhoods, all those kinds of things that you want to do when you have one-time money to make it really work for you. So Mackenzie's going to be working on those papers, and then we'll be bringing them to the council for consideration at a study session. But we had three initial ones that we wanted to work on, and it just became clear to me that we needed to do more work on those papers before the timing that we had. And since we're about to be on a vacation for a week as well, we just thought it would be better to come a little more fully baked to people as opposed to bring something and then you're going to have a lot of questions. So that's our goal, is to get the rhythm going on that so that we can regularly present you things. And again, the idea from at a meeting like this would be we would talk about them, get our questions answered, and then council will give an indication is, do we want to go forward and share that with the administration? Do we want to put it in a parking lot? Because, yeah, we like it, but we want to see some other ideas before we decide to forward to the administration. And then the third would be, no, we don't want to do anything more on that. So and then it would go to the administration council work group, which we are going to have our first meeting on the 11th. And we still haven't quite agreed our charter. I mean, the city council has already done a resolution of how this would work, but their job, the administration's job, is then if we say, let's say we wanted to do something with the smart meter program for the water department to make that work a little better, then they would give us their feedback on that and say, well, here's what we're already doing. This is what we need the most. We need a project manager to fix our billing system. Because that's, if you heard at the last thing, we're installing the hardware, but we have no idea on the billing yet. We should have the capacity, but nobody's working on that. So we need to have someone working on that if that's the project. So they would come back with that type of information and also their view on compliance. And then once that's done, then it would come back to council for final. So we council has set that process by resolution, but we still have a charter agreement that I would say is 85% done, and we just need to finalize that. And so that group will meet, I think, every Friday. So once we really get everything going, it'll be a rhythm, and we won't be trying to do everything all at once. And then the other update I would do before I take any questions is I think we have an agreement that we need to hire a lawyer/consultant vendor to be a compliance officer so that we don't get too crazy on this and don't get a bad audit. And so the idea is that we have an independent entity and then either council or the administration can consult them on an hourly basis and make sure that what we're proposing is compliant, or if it's not, how we need to change it to make it compliant. So that's the news since we last chatted about this last week. But happy to take any questions on anything. So.
Councilmember Stratton or Wilkerson, you're on the team. Any thoughts or input?
No, the only thing that I think the challenge is going to be, and we talked about this, is how, to make sure that this is connected to recovery and COVID, and that we're very clear on how that connection is made, and I think that's going to be a challenge on some of these, but I think we can do it and make it work. And I was going to say that Council President was talking about parking lots, and I was going to say, but you should have said you were going to pave Paradise and put up a parking lot. Just to make you laugh.
No, I'm allowed. Actually, I got a new term from the Sustainability Committee, and they're no longer using parking lots; they're using bike racks. So.
Okay, perfect.
Yeah, thank you.
Well done. Anything from you, Councilmember Wilkerson, on ARP? She may be on another issue. All right, I think this brings us to the close of our study session, unless there's something else that needs to come forward. We will see you all next week at the committee meeting on Monday. Thank you, everyone. This was a lot of information. Appreciate all your input. We will officially adjourn.